Justice Barrett?
So let me follow up on that. So you're saying there are services available, there's treatment available, so people would ultimately move off the street? Is that what you're saying? Because I think part of the premise of all of this, right, is that there are not enough beds for homeless people to occupy, and so there will be a mismatch, and there are going to be some people who can't be cared for. Are you saying that if your law is enforced, there is a way for everyone to be cared for?
No, I'm saying that's a policy question that is quite difficult, but these laws are an important part of the puzzle. They're not the only solution, and we don't believe that they are, but we think they're an important tool. And without them, we've seen what's happened on our streets. We've seen that people are dying in encampments. We've seen that cities are being forced to cede all of their public spaces. So that ultimate question is for the legislature and policymakers to figure out what the right solution, what the right mix of policies is. But the wrong answer is to do what the Ninth Circuit did here and to constitute.
Let me just interrupt you there. You're right. It's a very, very difficult policy question. And I asked you before about whether this was just about blankets or whether it went into having fires or urinating and defecating outdoors and that sort of thing. And Justice Sotomayor pointed out that this particular injunction did carve out those things and was just talking about sleep. But, you know, other cases have been litigated in the Ninth Circuit that have gone beyond that. And because the line is things that are involuntary, that are human needs, it can extend. It's difficult to draw the line. And whatever we decide here about this case is about the line. So can you describe for me some of the things that are difficult to figure out about the line? They're sleeping with blankets. What else?
Public urination and defecation, that is a serious problem. Those are parts of biological necessities of being human. A court in Sacramento addressed that, and the Ninth Circuit's opinions debated whether its rule would actually reach those things. I think any rule that we are wondering about and debating whether it would go that far, I think that is a sign that it is not a workable rule. The slippery slope here is very real. It's not just for camping and conduct that might be a biological necessity, putting aside tents and fires in cold climates. What other things would be allowed? All of the things that a human needs to survive, for example, potentially come into focus under the Ninth Circuit's rule, but also in other areas. Someone could say that my drug use or possession is the other side of the coin because I'm an addict, or because a person who violates other laws could say that I had a compulsion to do those things that I couldn't control. And the plurality opinion in Powell addressed that very thing and why it's so important to draw the line there. And when conduct is involved, and once the court gets into deciding which conduct may be excused under the Eighth Amendment, it is so far afield of what the Eighth Amendment was ever understood to address.
Okay, speaking of status and conduct, you've argued that Robinson was wrong and we don't need to overrule it, and I agree. I don't think we should overrule Robinson. You've also been kind of resisting the status. You've been resisting characterizing anything other than the drug addiction that was at issue in Robinson as status. So what if the law said it is unlawful and punishable by 30 days in prison to have the status of homelessness? Just go with me. Just assume that the law defines homelessness as a status and it is a status. Would Robinson say that that law is unconstitutional under the Eighth Amendment? Would you concede that?
And you're saying that that is a status?
Yes, the law defines it as a status, and it's a status.
Well, yes, and I think it looks a lot like Robinson under that hypothetical, but of course we disagree that it is.
I understand you disagree, but you are accepting that Robinson draws a distinction between status and conduct, and you're just fighting about the definition of a status?
It draws the line where a law has no actus reus, so I think that's the easiest line. I don't defend the line under the Eighth Amendment because I don't think actually that the court, I know the court didn't rely on any Eighth Amendment principles or history.
But the hypothetical I just gave you had no actus reus either. The status of homelessness. I mean, it could be, you know, 4 o'clock in the afternoon and the person is just standing outside the bus stop. Do you agree that if the law prohibited that, made that a crime, that under Robinson, whether Robinson was right or wrong, that under Robinson that would be a violation of the Eighth Amendment?
Well, I think the better framework is due process.
I understand that. Under Robinson, do you agree that that would be wrong?
Yes.
Okay. Thank you.